Hi.
I don't know what to do with Jacqueline Terry. Boardwalk versus Stan Young, 2502001. Come on up here. Give me 1 second. Do you have her number by chance, Ms. Austin?
I'll reach out, Your Honor.
Thank you. Your name?
Stan Young.
Counsel?
Good morning, Your Honor. Donald Dosinski on behalf of plaintiff.
Okay, any resolution?
No, not at this time, Your Honor. We're just going to request the trial.
Can I say something?
Trial?
Yes, can I say something?
Wait a second. You think you paid everything?
I have it here. That's all I was trying to show him to get an understanding, but he wouldn't allow me to do that. And then I was asking him, what am I paying for? He said DT, so I asked him, am I paying DT?
DTE, you mean?
Yeah, and I was trying to understand, that's why he confused me. And then I was like, well, wait a minute, let me go
Hang on a
back.
second. What is he in arrears on, rent or DTE bill?
Your Honor, he's in arrears for rent for May. He's claiming that he's always paid his rent in full on time. However, going back until March 1st, that hasn't happened when the DTE bill got attached to his account, and he's only paid $775 going forward. He hasn't taken into account the DTE bill or the $50 or the late fees, unfortunately. And so there's we went round circle here, unfortunately, and we're getting nowhere because there's only been payments of $775, and there hasn't, since March, there hasn't been payments that include the DTE bill and the late fees and the other fees that are on the ledger. So unfortunately, he is behind starting in March because of that.
Okay, can I say something? I never knew about the DTE bill. My DTE bill today is current to zero. So I never knew I owed you guys for DTE bill. What is the payment for the DT bill? I never knew that. And that's what I was trying to ask you.
Mr. Osinski?
The DTE bill was from November of 2024 through December of 2024, January through February as well.
So how much is that?
And the December through January. So those amounts were totaled $133.01.
And I can pay that. I didn't know that, but I can pay that.
133.01?
Back from March, and then going from March, we have the late fees that were added, and then the 7-day notice processing fee as well. And we have one late fee.
How much do you think he owes in total?
I'm sorry, Your Honor?
How much do you think he owes in total?
In total, Your Honor, he owes $1,688.01 in rent, plus a court cost of $184.17 for a total due and owing today of $1,872.18.
Okay.
Do you agree that you owe that amount?
No, because I have this much rent right here. Everything I paid in cash off this app, and it comes electronically to this phone. And I was trying to show him, but he was not willing to look. On my phone, he was looking at whatever he's looking at on his end. I don't know that, but I can show it to you right here.
I mean, I don't mind taking a look at it, but I'm telling you what's going to happen. Even if I agree with you, we're going to have a trial. It sounds like there's a dispute as to whether or not the money's been paid.
Okay, so I didn't know about the DTE bill, but as far as anything else about the rent, I'm normally up on top of that.
Did you pay your June rent yet?
Yes,
You paid your June rent.
yes, it's right here.
Is that right? Did he pay his June rent?
No, Your Honor. May's rent didn't get paid till May 31st. And that's according to him. It's not reflected on my end of the system yet. The last payment I have that's reflected in the system currently is from 4/25.
Is that right? April 25th, is that the last payment until you, hang on,
No,
hang on, until you made a payment on May 31?
no, every month I.
Tell me what date you made your payments.
Okay, so,
Give me the day you paid in May.
okay. That would be the 5th month, am I correct?
I don't know what you mean by that. Yes, May is the 5th month.
Right.
When did you pay it?
The 31st.
Okay, well, that's what I just said. That's what he just said. What other day did you pay in May?
Oh, in May?
Yeah.
Okay, that was for June, so. Again.
I want to know what date you made your payment in May. You said the 31st. Did you make another payment in May?
Okay. So, it's kind of, cause
Listen,
I'm trying to comply with you guys. One second.
you didn't make another payment in May, did you?
Yes, I made.
Besides the 31st? Did you?
No, I didn't make 2 payments in that month.
Okay, so you didn't make any other payment in May other than May 31, right? That's what he just said.
Okay.
Then he said the preceding payment you made was for April. And he's saying the May 31 payment was for May, right?
Yes.
Mr. Osinski, is that right or wrong?
Yes, Your Honor.
Okay. So he's saying you paid that late.
Okay, so I owe late charges for paying that late. That's what
You also owe June payment.
I got June payment.
Which one?
June payment is right here.
Listen to what I'm asking you now. Let's not make this harder than it is.
Okay.
He just got done telling me that the May 31 payment that you made was for the month of May, which would have been due on or before May the 1st. Right, Mr. Osinski?
That's correct, Your Honor.
You didn't make any payment for June yet, did you? Sir?
I didn't. Okay. Let me just say this here.
I don't need you to say anything. I want you to answer my question.
I thought I made this payment for this month because I paid twice in 1 month.
Which month?
It would have been 8/24. One for the 30th and the one for
August the 24th?
yeah, because I wasn't here. So yes, I paid twice.
Look, I'm just setting this for trial.
Okay, that's fine.
You guys can resolve this. You can go check each other's books before then.
Okay.
Okay?
Okay.
Yes, Your Honor. Thank you.
Give me a date for trial, Jennifer.
Judge, how far out do you want to go? 2 weeks, the 16th?
16th would be great.
Okay, 10:30.
We're going to set a trial for June the 16th at 8:30. You guys, this will be in person. You have to be in person. Now go back and run all your things and figure out, I don't want to go through this.
Okay.
I don't want you telling me the May 31 payments for May or June and him telling it's for me for May. You're going to have to go back to, how long you been leasing from them?
For about 5 years.
All right, well, you guys should be able to go out and figure out how many payments have been made over the last 5 years. Okay?
Okay.
And I will see you guys here on that date, June the 16th at 8:30. Thank you.
Okay.
I'm sorry, at 10:30. At 10:30. Yeah, at 8:30. 8:30. June 16th at 8:30. 8:30 in the morning. Hamptons versus Jacqueline Terry. 2502034. Jacqueline Terry, is she here? She's
No,
not
Your
here.
Honor, I have not had her come back in.
We better adjourn this to June 9th. Defendant to be in person.
All right, thank you, Your Honor.
Defendant to be in person. Give me a time.
I'm sorry, Your Honor, I was on a call. Did you need a date? A time,
Yes.
I mean, on which day?
June the 9th.
The 9th? The
Wait,
9th is 8:30.
Yeah, we're gonna June it to June 9th at 8:30. Okay, 8:30.
Thank you, Your Honor.
Thank you. Have a good day.
Yeah, have a great day. Thanks.
Too. Do I have, what'd I do with Bobby Bell and Tamisha Bell?
I'm here.
Here.
What'd you guys do now? You told me you listened to and understood the rights, right?
I do.
And how much do you think is owed, Mr. Bell?
Now I got a new statement from Citizens last week. They said the mortgage is $35,028.90. Plus I got a shut off from DTE for $2,556.51, which that total is $37,585.41.
How much were you renting this house to her for, sir?
Excuse me? I didn't hear your question.
How much were you renting the house for? 3,200?
I was nothing. She's just supposed to be assuming the mortgage, taking care of the mortgage, and making sure she paid the mortgage every month while she was there. I was making no money, no profit off of it, or nothing like that.
Were you
We used to be in a relationship. We used to live.
Slow down. Were you two in a relationship?
Yes, sir.
Yes.
And who's in the house is in your name, right, sir?
Yes, sir.
And somehow
And I am on a deed.
She is not.
you were what?
She is not on the deed. She says she's on the deed, but she is not.
I am on the deed.
And either way, that doesn't still make any payments, being paid. She hasn't.
You haven't paid the mortgage, ma'am, for 10 months?
Oh.
So let me explain, if I can explain, please. So the house was in bankruptcy, and then the house went from bankruptcy. It was in bankruptcy for almost 2 years, and then it went from bankruptcy to a modification. From a modification to a forbearance. Once again, when it was about to come out of forbearance, then we found the buyer for the house. After we got the payoff to sell the house to the buyer, we found out we were upside down in the house. So now Bobby wants me to go back and pay what he would have gotten if we weren't upside down in the house. We never had an agreement to pay, never had a lease or anything. Yes, I've been in the house. Neither one of us couldn't afford the house. So when the house was in bankruptcy court, and then went into the modification, while the modification was going on, we honestly thought that it was going to go into foreclosure.
Hang on a second. Slow down.
It's a mess. It's a mess. Yeah.
Why did you leave? Wait a minute. Why did you leave the house, sir?
Because we just didn't work as a couple, We wasn't.
I know, but you own the house and you left the house. And you're telling me she agreed to pay the mortgage while she was living in the house?
She did agree to pay the mortgage, and she has agreed to leave the house for it's been almost 2 years. She's supposed
Did you agree to pay the mortgage, ma'am?
I did not agree to pay the mortgage,
What did you agree to pay?
What did I agree to pay? Nothing.
Yeah. Nothing? What a great country. You mean you thought he was just gonna leave the house, let you stay there for free?
Absolutely not. The house was going into
Ma'am,
foreclosure.
I want you to listen to my question. Stop.
All right.
Stop. Are you telling me, how long ago did you leave the house, Mr. Bell?
It's been over a year, probably a year.
All right, slow down. That's all I wanted to know. You're telling me you left the house, no agreement, and just you can live here until?
No, it was a verbal agreement that she would take care of the mortgage until she was able to leave that house and find her something else. We've had sales for the house a couple of times, and she won't leave the house.
Hang on a second, guys. Wait 1 second.
I am the one who got the sales for the house.
The judge said to wait.
Can I please speak?
Wait.
Okay.
The judge said to wait. That means you don't say anything. Well, I can't say that this isn't something that I've seen happen before. I mean, this is what happens. People think they can commingle, live in different houses together. One owns, one doesn't own. One rents, the other doesn't rent. And now you guys got yourselves in a big pickle.
Mhm.
I mean, this doesn't seem right. You just can't imagine living in a house that has a $3,500 mortgage payment for free. I mean, this would be a great country. Maybe they'll let me live in their houses in Hollywood for free. I don't know what to tell you two. Don't interrupt me. I think you both better get some lawyers in here that know what they're doing. I'm adjourning this 2 weeks. You guys get some lawyers. That's what you need to do. This is an expensive asset you're talking about. You don't want to lose everything, Mr. Bell. I don't know what the status is. I don't want to know right now. But you gotta, how much is that house worth?
It's work. They did appraisal and they saying like right at 500 now. But she got it so upside down. I had to pay. I would have to pay to sell the house.
I have it upside down.
Hang on a second.
Your-
Hang on a
Your Honor,
second.
can I
Ma'am,
please say something?
Ma'am. I'm not gonna be here to referee this right now. I'm not gonna let you guys squabble across the cameras here, telling one why the other one got it upside down, or he did, or you did, or anybody else did. I'm adjourning this to June the 16th at what time, Jen? And you're gonna
10
come
a.m.
at 10 a.m. and you're gonna come back with some lawyers. And then we're gonna set it for trial. Okay? I mean, you guys are both hurting each other at this point, as far as I can tell. But I don't know all the details, but I'm sure I'm certainly not going to resolve them now. But when
Yeah,
you
tell
take-
him why you couldn't go to I had to get a restraining order on him. He was abusing me.
And
It's a lot of stuff. A
All right,
lot.
hang on,
You check the records. I've called the police here so many times before.
ma'am. That's the first I've heard of it.
Yeah,
don't-
because you wouldn't let me
Ma'am.
talk.
Ma'am,
Okay.
you need to get a lawyer.
Yeah.
Was he charged with anything ever?
No, because they could never catch him here. He
All right,
wasn't.
slow down.
No.
You said that you had restraining orders on him.
Yeah.
Did you get PPOs or were these?
I got a
Hang on, I didn't think I was done talking yet. Did you think
Oh, I
I was
didn't know.
talking yet?
No.
Would you please stop interrupting me?
Okay.
Did you have charges that you filed against him where he was the defendant in a domestic violence charge?
No, I
You
just
said,
got
hang on. You said you had a
Mhm.
restraining order. Did you go down to Detroit and get a PPO against him?
Yes.
All right. Is that PPO still in effect?
No.
Does that PPO have anything at all to do with the fact that you guys got yourselves in a deep issue here with regard to the loss of this property, whether it's Mr. Bell's owned otherwise or you own some or don't own some? Do you guys realize does that have anything at all to do with this?
No. Can I say this, Your Honor?
Why are you
Can't-
bringing up issues that have nothing to do with the fact that this house is apparently underwater and he thinks that you owe him $35,000?
The reason why I'm bringing it is to establish that he's doing this to be vindictive. That's why.
Might be, and I'm gonna hear all that at trial, ma'am. I'm not foreclosing you from arguing anything. I think that this
Yes,
is.
he's doing it to be vindictive.
Why are you interrupting me again? Please. He might be. I'm not saying he is. I'm not saying he isn't.
He is.
All right. Okay. Stop. I'm adjourning this to June 16th.
Look
With-
at him, happy that he made me cry. I'm telling you.
I'm not happy that you keep interrupting
He
me.
is.
I'm not happy that you keep interrupting me.
Your Honor, I'll just leave. I'll just leave. I
Wait.
don't have to
Slow
be
down.
here or anything. I'll just leave. I don't want to drag this out and have this man in my life anymore.
All
I'll
right,
just
slow down.
leave.
All I'm telling you is I'm encouraging both of you to get lawyers and maybe you can actually work together so people don't.
We're not going to be able to. He's crazy. And he's sitting here pretending like he's not. And I know it may seem like that I am because I'm interrupting you, but I have been through a lot when it comes to this man in this house. I dumped my money into this house just like he did.
All right, then maybe you guys should figure something out. I'm telling you what I'm suggesting. I'm telling you both you should be here in person June the 16th. I'm telling you, you should come with some lawyers and then we'll figure out, they can figure things out. June 16th at 10. If you don't want to, I don't know what to tell you, man. I'm going to hear you out. You guys come here with lawyers. We're going to set a trial date or they can resolve it. But I think you need some representation, both of you right now. If you're in danger of losing a house worth $500,000, I don't want to know how much debt you have in it, what your mortgage is or anything else. Just come here June 16th at 10. If it's not resolved that day, I'm setting it for trial. But you're going to have to prove, sir, that she agreed to pay that. If that's what it is. You got some obstacles here, both of you. I'm just telling you both, I think you'd be much better off with a lawyer on June 16th. And then I can set it for trial. You raised your hand, ma'am. Do you have anything else?
I do. I want to ask if I can just leave and not have to come back to court. I don't.
Lady, it's a scam orders, Your Honor.
What's that?
I put all those names on the thing because she uses several names. I've been to the police, made a report, and they know who she is and how she does because just like she doing this crime scene now, she'll do some stuff. She spit on me, did all kind of stuff, and then call the police and act like I'm doing stuff to her.
Partner, he is lying.
They
All
He
right.
is lying.
Hey,
get these eviction
Sir.
and filed a report
Sir.
so they
He's
would know.
lying.
Sir.
The reason
ma'am,
he's lying.
ma'am.
Yeah.
He's
lying.
claiming that you owe him money and he's asking me to evict you. So in answer to your question, if you choose to vacate this case, as far as I'm concerned, he didn't pay for a money judgment. This will be a moot point. He's not suing for a money judgment right now. So you can go consult with a lawyer. I'm not going to give you advice. I strongly think you should consult with a lawyer. I'll see everybody here
The
June
volume went out. I
16th.
can't
Hang
hear.
on. At 10 o'clock, and that will be in person. Okay, please? In person. All right? We'll see you guys then, June the 16th at 10 o'clock in person. Thank you very much. All right, now, is that it? Do I have Pitaways versus Pitaway here?
Your Honor, I did want to let you know on 25-01822, the appearance did come in.
All right, let me get that one out. All right, Sonia Regis versus LaVille. Pfizer, 2501822. All right, everybody's name on here. Ms. Regis, your name.
Sonia Regish.
Okay, ma'am. Mr. Barbie, you are representing,
Yes, Ms. Regish. Your Honor.
state your appearance.
Gregory M. Barbie, P71135, appearing on behalf of Sonia Regish, who is appearing via Zoom.
LaVille Pfizer, your name.
Hello, Pfizer.
All right. Did you apply for funding, sir?
I did.
and I just had to update it yesterday because of, we're into another month now.
Did he submit that proof of application for funding to the court within 5 days, Jennifer?
I didn't submit it. I had to update it yesterday.
Did he submit that application for funding, Jen?
Judge, I'm double checking.
Judge, I didn't submit it within 5 days.
Well, I told you had to submit it within 5 days.
I didn't hear, like, I didn't
I
hear
tell
that part.
everybody that. I tell everybody that.
Yeah, I'm sorry, I didn't hear that part, but I did apply for it.
I did. I tell everybody that. I just can't believe that I missed telling you that. I'm sorry.
No, I'm not saying that you, like, I didn't hear that. I'm sorry.
In your honor, if it helps any, my client filed this on her own, but she's no longer seeking the money damages. She just wants possession of the house.
Yeah. Let me check on something here. Jen, are you still there?
Yes, I'm here, Your Honor. I don't see that we received anything from at the court.
So you can tell me how much is owed, Mr. Barbie.
So rent would be $4,500, including June. There are no late fees. And then court costs would be $163.50.
So you're not seeking a money judgment?
No, we just want possession, Your Honor. We want to keep it simple. Just remove Mr. Pfizer from the house and move
Do you
forward.
agree that you owe that amount, sir?
Yes, sir.
All right, well, he's not asking for a money judgment. Right, counsel?
Correct.
I'm gonna go ahead and fill this out while I've got you here. Just give me 1 second. And what's the amount of your cost? 163.57?
50 cents, Your Honor, 163.50.
So I'm gonna give him a judgment by after hearing. You may be liable for money damages after moving if additional rent is owed or there's damage to the property. No money judgment is entered at this time, except it's a partial payment will not prevent the court from issuing a writ. So you owe $46.63. You have to pay that. $46.65.50. $46.63.50. My apologies. $46.63.50. You have to pay that amount on or before June the 12th. Okay.
Yes, sir.
If you pay that, you can stay. If you don't, you have to vacate by then. Any questions?
I appreciate. Thank you.
Have a good day.
You too.
Thank you, Your Honor.
Thank you very much. Thank you. I filled out the judgment. We'll send it out.
Thank you very much.
Do I have, which one are you here on, Mr. Ingram?
Granite Televalley, we're waiting for Mr. Albrecht and appears that he is here and I have spoken to him, so we're all good on that one, if we can go on the record.
All right. Granite Televalley. Jeez. Yeah, this is what happens. Which one? Granite Televalley versus who? Albrecht. Okay. Granite
Albrecht.
Televalley versus Albrecht, 2501710. Everybody's name?
Brent, take over the plaintiff.
Sir, your name?
Make the habit.
Good morning. All right.
Good morning.
What are we doing on this one?
We're going to be doing a consent judgment, Your Honor. I've got the total rent at $3,978.90. There is no dispute as to the amount owed. I let him know that the writ date would be the 12th and that he has that amount of time to either pay or vacate. And he has given me permission to sign his behalf as well, so I can get that submitted today.
So the total amount of the judgment will be $3,978.90?
Correct, Your Honor.
And sir, do you understand you have to pay that on or before June the 12th? If you do, you can stay. If you don't, you'll be evicted.
Yes, Your Honor, I understand.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal. Do you understand that?
Yes, Your Honor.
All right, I wish you well. Any questions at all? You have to pay that by the 12th or you're going to be evicted, okay?
And that's the final judgment, Your Honor?
Correct.
All right.
Sir, I wish you well. Good luck to you. Thank you.
Thank you,
Thanks.
Judge.
All right, do I have Pitaways here? Let me just see something.
Judge, we do have Zeal Credit Union too. They've,
Yeah. Oh, I know we do.
okay.
I'm gonna come back and take that one. Zeal Credit Union, come on up here, ma'am. My apologies. Zeal Credit Union versus Cindy Woods, 240-4676. Mr. Kennedy, your name?
Yeah, Clarence Kennedy for the plaintiff, Your Honor.
Your name, ma'am?
Cindy Woods.
Good morning. Any resolution?
Yes, Your Honor. We reached a consent judgment in this matter for, and we're going to put the terms on the record.
Okay, go ahead.
Yeah, so Ms. Woods agreed to make a $150 payment on June 6th and $150 monthly thereafter until the debt is paid in full. The amount due today is $2,261.54, and that will be accruing interest at 13%.
All right, do you agree that you owe 226,154?
Yes,
You understand that that's going to accrue interest going forward?
yes,
And you understand, according to the terms of the consent judgment, you've agreed to pay $150 by June 6th and the 6th of every month thereafter until paid in full.
yes,
And does he have your permission to sign your name to this judgment?
yes,
And you understand, so long as you make those payments, they cannot garnish wages. They can garnish bank accounts, tax returns, but not wages. Do you understand that?
yes.
Do you have any questions?
No.
And he has your permission to sign your name to this judgment?
Yes.
All right, counsel, you're all set. Sorry to keep you waiting so long.
worries.
Best of luck.
Thank you.
Don Pittaway versus Ronald Pittaway, 2502023. Mr. Pittaway, your name?
Donald James Pittaway, the second.
Okay, I don't believe there was a second mailing paid for here, was there, Jen?
No, Your Honor.
So I have to adjourn this, sir. We're gonna adjourn it till when, Jen?
The 9th at 11 o'clock, and
So
that'll
I'll
be in
adjourn it
person for the
until then,
defendant.
until June the 9th at 11 o'clock, sir. You come back here then, okay?
Do I physically got to come in, or can I come in on Zoom?
You can come in on Zoom. I don't have a problem. As long as
Okay.
you can operate it. We'll see you here then.
Okay, thank you, sir.
Have a good day. Is that it, Jen?
You do the same.
Thank you.
That's it, Judge.
All right.
Ms. Paulette, we're all set.
All right, I think the record is on. We've got a couple matters set for 10 and 2 set for 11. Attorney Lori Hines is here with her first client. Her other client will be here momentarily. Prosecuting Attorney Debbie Davis is present also. The first matter we're going to address is People versus Miranda Jean Lundgren. The file number is 25671FY. Ms. Lundgren was charged with resisting obstructing a police officer. The matter was reduced to attempting to resist or obstruct a police officer. I asked to set the matter out for a bit. I got the police report. Ms. Davis, I'd like to thank your staff. They also got me the videos, and I'm technically not very capable, but I got them, and I got them opened and I watched them, and they were very informative. So thank you for that. All right, having said all that, this is the time for a sentence on a misdemeanor charge of attempting to resist or obstruct a police officer. Ms. Hines, what would you like me to know?
Your Honor, if you watch the body cam, you're aware that the reason that the police even came to the McDonald's that day was because they said she was smoking methamphetamine, which they found nothing in the car. She had her dog, she was eating a breakfast sandwich sitting in McDonald's, and then the police came up, and it was then just a bunch of unfortunate situation. I just had one very similar next door with Judge Pattison, where basically the prosecutor said, and the judge agreed, but for the stubbornness of, my client, they got an R&O. So I think here it was the same. She was able to get her gun back and the ammunition, which I'm appreciative for the officer releasing that to her. I think this shouldn't be a probation case. It should not be a jail case. It should just be fines and costs, and hopefully she can move on and not have to deal with the situation like this again. Thank you.
Ms. Davis, you probably saw the same video we saw. What's your take of this?
Your Honor, I did not watch the video as far as the timing that we have to do things. This was one that Chief Assistant Prosecuting Attorney Robert had handled. So, you know, the notes that he left are that this started as a simple, you know, expired plate, and but for the behaviors, we wouldn't be here today. So, you know, I'd leave it to the court's discretion as to what punishment to impose for this. Thank you.
All right, thank you. The new statute, the criminal justice reform legislation, presumed there's no jail and no probation. I don't know that I need a probation, but Ms. Lundgren, what would you like to tell me?
Just that the incident was off of a false police report, and my tags were there in the report, in the police report. It says that he wanted to separate me from my pistol, which was in the back. I had just done my first CPL class the day before, but that's not what it was, because what he stated on the video was that he wanted me out of the vehicle, so I didn't turn my car on and run him over, because he said, I need to take off your plate. I said, you can take it, because I turned my car off. I wasn't going anywhere or resisting, trying to resist. He come back and said he wanted to search my car. I said, I don't give you permission to search my car. And then he says, well, I want you out of the vehicle because I don't want you to turn the car on and back up and run me over. I said, sir, I'm not going to do that. He's like, I want you out of the car. I said, I don't want to get out of the car. And that's when he proceeded to open up my car door and stick his arm on my throat. And here I am.
All right, you have zero remorse for this. I don't have any sympathy for you. You stubborned your way into an arrest. He said more than once, ma'am, I really don't want to do this. He's a police officer. He didn't just decide to come check you out. Somebody made a complaint that you were in there. I don't know whether it was valid or not. Somebody called Central Dispatch.
It's not valid. There's
I don't know that. So he
so
comes there, and because he's sent there by Central Dispatch, you got a dog in the car. Were you living in the car?
No, sorry.
It had so much stuff in it. I didn't know if maybe you were living in it temporarily or something.
What does that have to do with?
I don't know. So anyway, the police get sent there because somebody calls in a complaint.
That's right.
All right. So he comes there. You're not terribly disrespectful. You didn't want to do what he wanted you to do, but when your plate was invalid,
with it.
and up to the point where he asked you to get out of the car. And he has a right to ask you to get out of the car. The car's got an improper plate. He doesn't want to leave you in the car with the keys while he's behind your car.
That's what he
and
stated.
That is what he said. And you said, that's ridiculous. And maybe not.
Oh, I said, I'm not going to do
All
that,
right,
sir.
This is my turn to talk. Stop interrupting me. I'll give you a chance to say what you want to say. You said, I'm not going to do that. And he's like, lady, are you really going to do this? It was a huge pain for him and a huge pain for you, certainly. And then had to deal with your dog and your car. And it could have been so much easier. You could have just stepped out of the car. He would have taken your plate. And he would have got a ticket, which was a civil infraction. And that would have been it. And you're not even sorry now. You could have just made this so much easier. Yes, he had a right to ask you to step out of the car. The car had an unlawful plate. He was going to take it. No officer is going to get behind somebody's car while they're in it with the keys in it. He didn't ask you for the keys, but I don't think he would have given them to him.
I would have, yes, I would have.
I don't know why somebody called. I didn't get the central dispatch tape, but they didn't find anything. So you're right. There wasn't anything to that.
Right.
And Your Honor, I guess just to clarify too, admitting that you have the pistol in there, absolutely bring that up to the officer. But the officer isn't just going to blindly trust that it is where you say it is in the vehicle too. So for safety issues, that is where I'm looking at, the
But I
officer.
can understand that point of view. This is when he came up to my vehicle and asked for my license, I gave it to him. And I said, I'm also going to tell you, I have a pistol in the car, and I just did my first CPL class. It's in the back, it's locked.
But again, that's an expectation that everybody that they talk to is going to tell them the truth, and they can't make that judgment alongside. So I don't want you to feel like this officer was.
I mean, I can understand that point of view. That didn't run through my head when he was asking to take my plate. He didn't say that to me. He didn't say, I want to remove you from pistol or anything like that. He just said he was afraid that I was going to back up, turn the car and back up and run him over. And I said, I'm not going to do that. So.
All right. Well, so he trusts you. You're not going to do it. Who knows the next person? And he knows you've got a gun in the car. He wants to get you out of the car.
Like I said,
and you dumbassed your way out of it because you wouldn't get out of the car.
I didn't.
And you're like, I'm not.
I think that it was necessary, but I mean.
It was necessary. So how would about 90 days in jail be necessary? I see zero remorse or repentance for you. If I were to give you a drug test today, what would it show?
Nothing.
All right. So you're not struggling with anything?
No. Where is this?
No, not at all.
Those, I can't make her be.
I mean, I'm following the law. Like I just.
You weren't following the law.
How can I be a citizen that I have no priors here in Michigan. I've lived here for 7 years. I don't do drugs. For one, I don't understand where that's coming from. It is a huge issue for me. I've already had to pay to get my car out, all that stuff. I mean, I don't understand how you're saying that it's
well, I can't
no
make
consequence to me.
We're talking two different languages. You're concerned about your rights and privileges, which you have. But at some point, the rights of the police officer supersede yours.
Which it did, yes.
He knows you got a gun in there. He's going to get behind your car. There's a dog in there. And he's by himself. He doesn't know what's what. Someone called and says you're using drugs at that location. He hasn't done any investigation yet. He doesn't want to leave you in the car with the keys and a gun while he doesn't know you from Adam's cat. Every day, police officers are shot in this country by people who, for whatever reason, don't want to cooperate with the police. He's following his training, and I thought he was quite respectful to you. You didn't do what he wanted to do.
Also, this is my first time owning a pistol, so I guess that didn't register when he pulled me over. I've never had trouble before, so when I said that I didn't want to get out of my car, it had nothing to do with that. But he stated that there was nothing going on when he first pulled up. So, I mean, I guess I'm not familiar with everything, so I don't, it was just a whirlwind.
I can't make you be repentant, so I'm not gonna do that. Are you employed somewhere?
Not at the moment.
What kind of work have you done?
Factory work.
Really, the sum total of your resisting was refusing to get out of the car. Once you got out of the car, you were not any more disrespectful than you were before. You cooperated, you were concerned about your dog, but this was your own fault. I believe you spent 2 days in jail. You got arrested on the 14th.
Looks like we went in on the 13th and was
Bond was
released on the
posted on the
14th.
7th. Were you in you weren't in jail that long? How long were you in custody?
I would say about 2 days.
The release date was 4/14 at 16:07.
And then at some point, they must actually serve the warrant, and then she had to post again on May 7th. I think she spent a total of 3 days. We'll call it 3 days. Credit 3 days. As I indicated, I don't know any reason to put her on probation. There's a presumption of no jail. As she indicated, I don't know what she has in other states. She doesn't have much of anything in Michigan or in our system.
A couple OWIs.
Yes, and what state was that in? Indiana? All right, there is $125 fine, a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. That's $400. She did post a $1,000 10% bond, so the court keeps 10% of the 10%, which is $10, and $90 can be applied to the fine and cost. So it shows $310. Can you pay that by the end of July? Or would you rather have a payment plan?
Whether you extend that a little bit more. Some issues going on right now.
All right, I'll make this due by August 15th.
Yeah, you can.
The word of advice for you and anybody else is the officer asks you to step out of the car, step out of the car. All right, Ms. Lundgren, you're free to go. I don't know that there is a good answer to that question. All right. All right. Morning, Mr. George.
Morning, Your Honor. Morning, Steve.
Good morning. You're Kiara Nicole Mullins.
Yes.
I met you a week or two ago, a little bit ago, when you came in here on this old warrant after turning yourself in. The complaint alleged that in December of 2022, you assaulted your boyfriend, living together, dating relationship, James Cooley, as a second or subsequent offense. That was a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. It was authorized by former Assistant Prosecuting Attorney Casey Johnson. Then you were given an appearance date, and we didn't see you for 2.5 years. And you got picked up and arraigned on the bench warrant. The matter was set for sentencing today. You gave an update, and although you were charged with assaulting Mr. Cooley, you certainly told us what your current status was, that you went to get away from him and he followed you there. Anyway, I recall the bench warrant, reset this with Ms. Hines, and gave the prosecutor a chance to give any input. Ms. Hines, what would you like me to know?
Yeah, Kiara's back in Michigan, as the court's where she's living with her mother. It's my understanding that she still wants no contact with Mr. Cooley. I think she's, I watched the video of her arraignment back with you, and it sounds like she's still fearful of him. But I'm glad she's been in contact with me when she came back, said she was coming back. So she's done the right thing, that's for sure. And if the court remembers, when we had the pre-trial and she entered a plea, it was a plea to DV first with probation request. That's what happened back in January of 23. Hopefully things are better mentally for you, taking medicines, maybe getting some mental health treatment. I was the attorney for Kiara when you were in the juvenile court. Do you remember that? So I know she struggled, Your Honor. And I know her parents have always been committed to her and wanting what's best for her. So I'm glad that she's back home living with them and hopefully getting some mental health treatment that I think is important for her. Thank you, Your Honor.
Ms. Davis, you didn't have the benefit of being here at the time of her plea. She presented as a victim of assault and from this defendant. Now, 3 years later, and she came back here to take care of this. I don't know if we got any victim input from him at the front end or anything now. Have we heard anything from the complainant?
We've not heard anything lately. When this occurred, at some point he did ask to have the no contact lifted back in 2022. I guess I look at this as I'm glad that she turned herself in. I guess it took a couple of years to do so. It looks like from the ROA, she had been in contact with the court, wanted to do things by Zoom. She's out of town, those sorts of things, but never really followed through. I guess what really strikes me is her assaultive history and the number of times that she's been arrested, been in trouble, resisting, obstructing, assault and battery, DV. This instance, I read the police report and she alleges that he shoved her first into a door, but then her striking him with a crutch, swinging at him twice, missing his leg, but hitting him in the head and causing a laceration. The witnesses that were there, uninterested neighbor witnesses, didn't see the shove that she claims, but they did see her striking him with the crutch. So I hope that in the last couple of years she has matured, and didn't have them run another lean to see if she'd had any more arrests anywhere. If she's been in Ohio.
I didn't think to do that either. I asked her that and she said no, but I didn't think to run another lean.
We both went to jail in Ohio when
you told me the charge got
broke in my
dismissed.
house and attacked me in Ohio. Same situation that he did here.
And you told me those charges were dismissed.
Down to the obstructing justice, because when they were arresting us, we were arguing again. So they only charged me with that and dropped the assault charge. And because of my Ring camera, because he broke in through my door.
He was arrested for assaulting you. An Ohio case was dropped.
Yeah.
I don't think you told me they arrested you too.
No, yeah, we both went to jail that day.
And you ended up being convicted of obstruction of a police officer?
Of a justice, because they were trying to take my phone and his phone for the Ring camera, and he and I were like still kind of arguing, and I smacked the phone out of his hand, and that's what they charged me with.
Well, those are the very things Ms. Davis is concerned about, your temper.
So with that, I'd leave it to the court's discretion.
Well, she has a prior domestic violence. She's not eligible for a deferral. This is several years old. She spent 2 days at the front end and 1 day at this end for 3 days. Are you on probation in Ohio?
No.
That case is done?
Yeah.
All right. I saw you in May, a couple of weeks ago. What have you got more established since I saw you last time?
I'm not planning to get my Medicaid and things switched over to go to Covered Bridge for the mental health aspect, and my mom's letting me stay with her, and I have no contact with him in any way and haven't.
All right. I think I'm gonna do a probation to make sure these things happen. I'm gonna put you on a 12-month probation, which means you could be discharged at the end of 6. I'm gonna order 13 days, credit 3 days. And of the 13 days, 10 are deferred. You're not gonna go to jail if you do what I ask you to do. I think you could benefit from the women's anger management class, but I think you already did it once. But I'm gonna make the fine 0. You don't have much money. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. $480 probation oversight fee. We're gonna do no drugs and no alcohol, no assaultive behavior. Cooperate with CMH. Sign a release. CMH is synonymous with pivotal. Take meds as prescribed. No contact. James Cooley. You have children together, correct?
No, my son's not his biologically.
All right, I'm gonna do this probation to help you get plugged in here. If you're gonna live here, I wanna make sure you're getting services. I wanna make sure if you need community mental health or pivotal assistance, you're getting it rather than talk about doing it. If you're prescribed medication, I wanna make sure you're taking it. Ms. Davis kind of hit the nail on the head. You've got anger issues, and I'm not saying that you weren't a victim here and haven't been a victim since, but this behavior seems to be continued into Ohio. All right, let me give you a referral downstairs to the probation department. I can always amend the probation if we feel that women's anger management is appropriate. The good news, Ms. Mullins, like I told you the last time, you don't have a warrant hanging over your head. This matter's been resolved. We went through with the sentence. You're on probation. No assault or threatening behavior, no drugs or alcohol, including marijuana. Cooperate with pivotal. I want you to make an appointment, not talk about making an appointment, and follow their instructions. You take this form downstairs to the probation department, they'll get you started on that probation. Let me add those totals up, they're not good. 125 plus 150 plus 480 is 755. You did post some bonds, but they got forfeited a long time ago for you failing to appear. And I gave you a PR bond and you held up your end of the deal because you came back when you were supposed to. So good luck to you.
Thanks, Your Honor.
Yes. Yep. Yeah.
Let's do Holman. Is Natalie Welch here?
No, Your Honor.
Okay.
I know.
Well, I didn't know what to do with it, and you don't have any better idea than I did. I don't even know what to say about it. We'll set that one aside for a minute. Good morning, sir. You're Alexander Holman?
Yes, I am, Your Honor.
I've met you several times, and we're here today for sentencing in this matter. Also present is your lawyer, Mr. Tim George, and Mr. Matt Huff from our probation department, and Deborah Davis from the prosecutor's office. We've spent a lot of time on this case. I don't want to say it was wasted, but because I think maybe it was well spent. You are on a collision course, not only with a tree, but something a lot worse. We had discussed placing you on our sobriety court. And frankly, I would have maybe liked to have you in my sobriety court, but you live in Dowagiac. So we've been working for several months on getting you into the Cass County Sobriety and Treatment Court. We have a good working relationship with Judge Renfro. In fact, she was working on this last night. She sent us an email Sunday night. So it is the recommendation that we place you on a sobriety court sentence under the supervision of the Cass County Sobriety Court Treatment Program. For many years, they didn't have one. So we've done a number of cases from Cass County, maybe 20. Edwardsburg, Dowagiac, Jones, Union, Cassopolis, Marcellus. But Dowagiac's a long way from here to there, and try to do this from there. We now have another option. We've had good success with taking defendants from other jurisdictions, Kalamazoo, Kent, and we've had pretty good success with our defendants going to other jurisdictions. I like and trust Judge Renfro, and I think she'll do a good job supervising this. Mr. George, anything you'd like to add?
I just think that in talking to Alex, as we've gone through these hearings, I think he's excited to get started. From the very first time he called me, he acknowledged there was a significant issue there that needed to be addressed. And fortunately, I know the facts here are not good, but they could have been much worse. But fortunately, he is here. I think that he's been progressing on a good pace since we entered the plea in this case, kind of awaiting the ultimate resolution. And I think it's a good resolution for both Alex and society. So I'd just like to thank Cass for taking on this case, and the probation department here, and Your Honor for getting everything in line to make sure that we could get this done in a way that, although I think he would have been able to do it here, it is much more feasible to do it over in Cass, because he's in Dowagiac. He's going to be working, it sounds like, outside of Dowagiac. He does have an interview coming up. So everything's trending forward. I just wish him success, and hopefully he can complete that program without any issue. Thank you.
Well, if the wheels fall off, the case comes back here, and it'll be up to me. But yeah, as Mr. George said, the facts weren't good. Ms. Davis, anything else you wish to add here?
I'd like to go last if that's okay.
Okay. Mr. Holman, anything you want to say?
I feel like getting into Cass's sobriety court would be a good thing for me, and it would have a great impact on my life. To go through a course, to be sober and sustain sobriety, and I feel like it'd get me to where I should be already at if I was not to go down the path of drinking.
How old are you?
I am about to be 25, and it's time for me to get my stuff together.
And we had talked about that. 25 is kind of young for people to internalize the fact that they have to make some serious changes, or they're gonna have a life of misery, or worse, a short life. But we've got a young man right now who's about to graduate, who's younger than you, and he's done a really good job. Mr. Huff drew this assignment. He's been involved in the process of trying to get you through all the hoops, which we still have a few more to do. But Matthew, specifically, what are you recommending that I do as the sentence?
I think the primary component, Your Honor, of a recommendation would be that he participate in sobriety court over in Cass County. I do believe that the case facts in this case in particular potentially warrant some additional consequence, and the logistics of it are going to be a little bit difficult to figure out if the court's inclined to do something above just assigning him a probation and deferring all jail. But this is something where I found out he was essentially on basically like a junior probation. It wasn't true probation for the OWI, but he had to call in every now and then. He had some fines to pay. I believe he had a class to attend as well.
Well, that was another factor. He had a drunk driving in Cass County in 2024.
So that's what he was going through at the time.
Yeah, so
then this happened, and this is where he totaled a vehicle. He walks down the road to a residence where he was heading anyway. It was a bad night. He had, there were a bunch of different factors going on. And he ended up owning up to it. I believe it was another man who responded to the residence, basically had a chat with him, a frank chat about, hey, are you going to own up to this, or what's going to happen? And he said, yep, I'm going to take the responsibility. But he could have killed somebody that night, could have killed himself. He knows this. We had a good chat about how bad the case facts were. So
I think that the case facts warrant additional jail. That being said, he is going to be going into sobriety court. And I think typically when we do these in our own county, we defer a bunch of jail. If it's appropriate, we do some weekends. And so I'm making a recommendation for 4 days in jail to be served. And then he can get going with his sobriety court in Cass County. If we need to schedule those to where he has somebody to come pick him up. But I just can't make a recommendation for just, a sweep under the rug, given the facts that he was twice the legal limit, total the car, could have easily wiped out somebody at that stop sign or at that intersection rather.
And he was on probation in Cass County.
Essentially a probation, it wasn't quite one.
And they didn't pursue a probation violation.
It wasn't a technical probation violation. To my understanding, it's some sort of an in-between, so.
Well, they were familiar with him. Ms. Davis, what's your thought?
When reviewing all of the information that I have, he's got 3 kids at home. There was an argument with his girlfriend and he had been drinking. Those things are sometimes related, especially with the type of alcohol and the amount that he was drinking, and his acknowledgement that there's addiction issues genetically. He presents today as somebody who's going to do the sobriety court and be successful at it. But I do have concerns that he was on probation before and couldn't stay from drinking. So I hope that he understands that this is a very important process that he needs to take seriously. I am thankful that Cass County is willing to take him, and glad that we have a good working relationship with them. I just, for his family's sake, for his sake, and for the protection of society, he's got to take this seriously. Otherwise, we'll be recommending a significant amount of incarceration.
I think you're right on. All right, Mr. Holman, we're going to give this a shot. I'm going to order 24 months probation. 180 days jail credit. How many credit does he have?
I thought I printed my status report out, or my.
You do, I have it. Let me see here.
And Your Honor, he pled to a first offense.
I show that. Oh, yeah, 90 days. Thank you, Tim. In fact, I thought that when I did it, and then at 90 days, can't do 180 days on a 90-day.
I believe he has 1 day credit.
It was almost like there's a page missing.
Strange.
But all right, 90 days credit 1, leaving 89 days to do. The 90 days ordered, 85 are deferred, so you owe 2 weekends. You want to just have them do the 4 days up front and all at once? I'll let you, well, the problem is you're at the logistics of transfer to Cass County. I'm going to make the fine 0 because you're going to have some costs in Cass County as well. $75 crime victims' rights fee, $50 state minimum fee, a $100 screening fee, $150 attorney fee. And I'm going to do a probation oversight fee of $960. We can reduce the probation oversight fee. If Cass County is going to charge them a fee, we can waive our, I don't want to put them on double probation. With a probation, you are allowed to amend the terms. Was there a police reimbursement?
I did not see one in the police report, but there was an accident and a blood draw.
It may have been something that was buried in another part of the report that didn't get sent. This was back in December, so I will get that in.
I think that I'm gonna, who was this? Sheriff's Department?
Sheriff's Department.
I'm gonna do $140 to the St. Joe County Sheriff's Department. Set that up. Now, I'm not gonna double dip you. If Cass County is gonna charge a probation oversight fee, I can waive mine. But this $125 of cost is mandatory. $150 attorney fee, $100 screening fee, $960 probation oversight fee, and $140 police reimbursement. That's $1,475. I don't believe we have any bond.
Your Honor, the reimbursement was filed at the time by Deputy Middleton requesting $255, which
Oh,
is the
thank you.
standard for an arrest with blood draw and accident. And I can send
All
that to you. And.
Well, thank you. All right, let me redo that number.
Sorry.
125 plus 100 plus 960 plus 255. 1440. That's not right. It's less than it was before. 125 plus 100 plus 150 plus 960 plus 255 is 1590. As I indicated, I can waive some of the probation. No drugs and no alcohol and sobriety court referral. You're an experiment, Mr. Holman. I want you to make this work. We've had a good working relationship with Cass County probation. We're next door counties. We share cases sometimes. You're plowing the field for the next guy to come behind you. So I want you to get in that program and be successful in it. Or they're going to say, we don't want any more of your people from St. Joe County. You came over there. Plus, as Ms. Davis said, you got 3 kids. This is time for you to change the course of your life. You got some paperwork to do, transfer stuff. They're working on it. It's a lot more procedurally difficult to make these transfers. Everybody has to be on board. You start with Mr. Huff. We're going to see, we're going to do these 4 days off the bat or schedule them as weekends, but you almost killed yourself. Okay, I'll give you some time to think about it.
Thank you.
You're good to go. All right, let's call up the deputies. Would you call the hall for Natalie Welch? All right, very good. Thank you. He's already checked. All right, the next matter we're going to address is People versus Natalie Welch. File number is, I'm just going to leave this as it is and turn it off in a minute. More of our technical problems. Miss Welch was charged with possession of methamphetamine, possession of cocaine, and possession of other controlled substances. She was arrested on November 2nd of 2024. Then the warrant got issued and she got arrested on April 14th of 25. It was set for a felony charge, was reduced to a misdemeanor, pled to use of a controlled substance on April 29th. She was set for a sentence today with a pre-SI interview on May 16th. That didn't go very well. And she's not here this morning. I frankly didn't know what to do with her. We're talking fentanyl, heroin, cocaine, methamphetamine, not trace amounts either. She's 20 years old on the road to nowhere. And so I referred it to Mr. Frazine for some help. I think he was just as frustrated as I was. And now she isn't here. Have you had any contact from her?
I told Dan she's called the office, because Dan told her to call the office, and every time she called, I was either in court or I had just walked out the door. Like she called like late in the day. And so then I haven't had no contact. She has a working phone number. We sent the notice by email and mail. So she got it 2 ways, as to the date of sentencing.
Plus I gave it to her in the courtroom.
Okay, so, yeah.
And I reminded her, and she said she'd be here, but
I don't know.
Was she staying with her parents?
Says she was
Yeah,
staying
in
with her
Colon.
parents in Colon.
Yeah,
Do we have like a number where you can call and see if she's?
I have a phone number
there?
for her, Your Honor. Do you want me to write it down for you?
I've got
Oh,
it.
there
Here
she
she
is.
is. All right. And that arrives late. All right. Let me stop this.
Your Honor, would it be possible we could get Autumn just to have a test today?
Yes. We're gonna do a drug test today to see what we're dealing with. All right, we are live, and we'll have a juror that has to be excused because she's gonna be studying in Germany through an overseas program with the University of Michigan. I guess that will get you excused as a juror.
We have Zoom.
She could zoom in.
Just kidding.
Good for her.
She has to bring back some specialers.
She was unable to give a specimen, but she admitted to using marijuana and methamphetamine 2 days ago.
All right, thank you. All right, well, let's then address the sentence in the matter of People versus Natalie Nicole Welch. Ms. Welch was, as I stated, I think before she got here, charged with possession of methamphetamine, possession of cocaine, and possession of heroin or fentanyl. Heroin and fentanyl. 4 counts, was reduced to 1 count of use of a controlled substance. The matter was set for sentencing this morning. Daniel Frazine has been tasked with preparing the pre-sentence report. There was some trouble getting her in for the pre-sentence report. We did finally get it done. Mr. Frazine shares many of the same frustration I do in figuring out what to do here. Ms. Hines, what would you like me to know?
Your Honor, before we go forward, maybe I would ask that the court consider canceling her bond and having a drug test before we go forward based on her admissions of use and her admissions of continued use while on bond to Mr. Frazine. I have concerns that she might not be coherent and with us enough to do a sentencing today. I'm certainly willing to have her come back tomorrow or when the court is available, but this is
fair enough.
A pretty significant reduction that was given.
When people come in with alcohol, I had a young man here recently, his blood alcohol level was 0.14, and we were about to do the sentence. We have a standard of how high is too high. And he was almost 1.5 times the legal limit. You can't proceed with a sentencing when the defendant's intoxicated. So we canceled his bond, spent the night in jail, and we proceeded with the sentence. It's harder of a standard to know with these sorts of tests. And we don't have a test. We have her admissions. And so I don't know whether she's coherent today or not. She seems to be. She was 20 minutes late, but I don't think that was her own fault. I think other people brought her here. And so she's still struggling with, frankly, I was more concerned about the fentanyl than I was the others, but I am very concerned about the meth as well. How old are you, Miss Welch?
20.
Yeah, so you're not even old enough to smoke marijuana yet. And so, Ms. Hines, what's your thought?
Natalie did say she probably would test positive, so she was honest with me. I don't know what to say. I think she's here. Her mom brought her here. We have a pretty detailed pre-sentence investigation report, and she did indicate that she has started Celebrate Recovery. So that she needs some help. 20 years old. It's concerning that, like you said, Your Honor, she's used pretty strong illegal substances that really will ruin her life.
Yes,
she doesn't get control of it.
The struggle is between just letting her go over the waterfall or trying to intervene. She is 20. And these weren't trace amounts, 1.67 of meth, some 1 point some of or 3.5 of some other stuff, then the cocaine, the fentanyl. I forgot they were in there. Addicts don't forget they got user amounts of controlled substance in their possession. She doesn't know whether her boyfriend uses drugs or not. So I don't think she was really upfront about everything. So I'll cancel the bond. I can't get in my scheduling profile right now. Laura, do you know what your schedule looks like this week?
Tomorrow I'm in Judge Patterson's courtroom at 9:30. And then I have a sentencing from 11:30 to 5 in Sturgis.
11:30, a sentencing.
A divorce mediation.
Oh, okay.
Sorry.
It just feels like.
It feels like it's. Especially this one. So I will be in mediation.
How are you for Wednesday?
I have an adjudicatory trial. Yeah, that's set for all day.
How are you for Thursday?
I have some people in my office, but I can work around that, Your Honor. We can move people if I need to, so.
Laura, what do I have for Thursday? It wouldn't let me log in first thing this morning in my ongoing litany of technical problems. I still can't get the Kramer box to work for the Javs recording and wouldn't let me log into the AS400. So
I'm assuming you have, does he have PCs tomorrow, PECs tomorrow?
I have PCs tomorrow.
I mean, I could be over here in the morning. I like us on next.
All right, why don't we set it for 10 o'clock tomorrow?
That's fine.
Does that work for you, Ms. Davis?
I'm doing PCC, so I'll be here. I would like to have a screen still up there.
Well,
just to verify.
then there's some, we have to transport her to Three Rivers and somebody has to pay for it. We don't have a funding source to pay for her test.
I mean, I think if it's just a matter of giving a urine sample and she's not able to right now, I can, maybe she could within the next hour.
Okay, so even get a urine sample.
Yeah.
All right.
I'm around all afternoon too. I mean, I have
we'll
some
set it
hearings
for
with
tomorrow
Judge
at 10.
Patterson, but other than that, I'm available this afternoon.
I guess I am interested, Ms. Davis, in knowing whether there's any opioids in there as well. So we're gonna wait until we get a test. All right, tomorrow at 10. Let's see what I got. No, I tried to call Chris because it won't let me in the AS400. Thursday would have worked also. All right, Miss, we'll take it up tomorrow at 10 a.m. here in this courtroom. We're gonna have her wait till she can give a sample. And we'll see really what it is we're dealing with.
Can they give her some water or something to drink?
Yeah. I'm concerned if there are opioids in there as well. We hadn't seen cocaine in a while and it started to make a resurgence. All right, Ms. Welch, you go back at the lockup. At some point, she's gonna need to get lunch, so I'm not sure. We'll work with Autumn and see what we can do.
Maybe call out and have them say we're free.
So you want her taken to the jail then, sir?
Hold on to her for now, then we'll see what Autumn wants to do.
Stand up for James, be in the back, please.
Should I leave her phone in here? Just for now? Natalie, I'll take this.
Just bond cancellation.
Yes.
All right. See you tomorrow.
Thank you, Deborah.
Thank you, Your Honor.
Well, two cases, cause numbers 22-40070 and 40075, the state of Texas versus Stephanie Watkins. Are you Stephanie Watkins?
Yes, sir.
Present, your attorney, Ms. Carlzo, and the state's attorney. Does the defendant waive formal readings of these indictments? In these cases, can we proceed in summary?
Yes, sir.
In summary, 40070, each of these alleged first-degree felonies. I guess we're not going on paragraph 2.
No, sir.
Okay, just paragraph 1.
Yes, sir.
Each of these alleged first-degree felonies, each of these similarly alleged that on or about October 21st, 2021 in Jefferson County, Texas, you committed in 40070 the first degree felony of aggravated kidnapping, and in 40075 the first degree felony of aggravated robbery. Do you understand what you're charged with in each of these cases?
Yes, sir.
If convicted, you face a term of any term in each case of not less than 5 years, nor more than 99 years confinement or life imprisonment, and a fine up to $10,000 when they assess. Do you understand?
Yes, sir.
Agreements have been reached where you would be pleading guilty, sentenced to 10 years in each of these cases
Yes.
to run concurrently.
Yes, sir.
Is that your understanding?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'll show you in each case what's marked as State's Exhibit 1 here.
Yes, sir.
Oh, sorry. Thank you.
You need to sign the bottom of the
This is it.
Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
The bottom you're signing, it states that you understand everything and you also giving up your rights to appeal if I follow these agreements, which I intend to do.
Yes, sir.
All right, State's Exhibit 1 is tendered into evidence in each of these cases without objection admitted.
No objection.
Among other things, these state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God in each case.
Yes, sir.
State's Exhibit 1. Made a part of the record for all purposes. Pre-sentence reports away.
Yes, sir.
I'm going to follow these agreements and find in each of these cases you are indeed pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each case to find you guilty beyond a reasonable from State's Exhibit 1. I'm going to follow these agreements. You are hereby found guilty beyond a reasonable doubt of these first degree felonies. And you were hereby sentenced in accordance with these agreements to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each of these cases. They shall run concurrently. Do you understand what has happened today?
Yes, sir.
Anything else?
No, you're right.
That's all. Thank you. Reagan?
Which one?
Her case was specially said. Stephen Adams, what is this?
If we could have them sworn in, Judge?
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer?
If I may, please, the court.
Go ahead.
Mr. Adams,
And it's Mr. Burbank is here representing you and the state's attorney. Go ahead, Mr. Burbank.
Mr. Adams, we have now been picked number one for trial. You understand that?
Yes, sir. I'm not ready for
Hold on, let me go through it and then you can. And you understand that you're currently under indictment for aggravated kidnapping and aggravated robbery, correct?
Yes, sir.
And what I want to get on the record is the plea offer that you've rejected, okay? After much negotiation and going back and forth with you and the state has agreed to settle this case for a lesser included aggravated assault. You understand that? That a yes?
I'm understanding this, sir.
And that they would dismiss the aggravating kidnapping, aggravated robbery. You understand that? Good. And that also that we would go unagreed to the judge with a cap of 15 years, which means that the judge would have the full range of punishment. Could be probation, could be 2 years up to 15 years. You understand that?
Yes, sir.
You understand that by rejecting this, you are looking at first degree felonies. You understand that, right?
Yes, sir.
Okay. And that after much thought and going back and forth, do you want to accept or reject that offer?
Not accepting it.
Okay. All right. Is your decision based as freely and voluntarily done?
Yes, sir.
And that no one's made any threats or promises against you, correct?
Yes, sir.
Okay. I have nothing further, Judge.
All right. Anything else?
I'm not ready for trial. I wanted to move forward as pro se. I wanted motions that I filed ruled on before trial, so I have a fair trial. And there's other motions that I wanted to file prior to trial. I never got to file.
And I'm just not ready yet. So I got the motions right here for continuance and to move forward as pro se, and that's what I would like to do. I'm aware of the risk and everything.
What do you need a delay for?
So I can get some motions filed.
Well, yeah, so what? What did the motions say that need a delay?
The motion say that I wanted to file? Or-
Yeah. What are you asking for?
One of them, I wanted to file for recusal because there's bias in this courtroom. I'm not gonna have a fair trial at all. Another one, I want to challenge the grand jury proceedings to make sure due process was followed.
Well, what's your complaint about the grand jury?
I don't think due process was followed, like this.
For what reason?
That's a common thing in this county. It's very common. I read case law and everything where people's had their grand jury stuff pushed through and there was steps skipped and everything and case has been dismissed, and I would just
What
rather.
case are you citing?
There was one with Hartman where the guy was falsely accused of interrupting their courtroom or whatever, and because the guy named Alfred wasn't sworn into the district attorney's office or whatever, they dismissed his case. Like I got them all wrote down and everything. There's probably a few of them.
I'm familiar with it, but you're wrong on the facts. But what else do you have? What else?
I got the motion right here. I'm not happy with how my attorney's been doing stuff for me. Like,
Okay. You want to represent yourself? Okay, you can do that.
I will
Do you understand all the consequences that are part of representing yourself? You have to know the rules of evidence. You have to know the procedure. You're going to be, and if you keep interrupting me, I'll hold you in contempt. Only one of us can speak at a time. This lady next to me has to put everything down. And if two people are speaking over each other, she can't do it.
Yes.
I'm not going to be the one in trouble you want. All right. Seems like you want to control proceedings, and that's not the way it works. But you can represent yourself. This case is over 2 years old. How long have you been thinking about representing yourself?
Since John West wasn't doing anything for me at all.
How long is, I'm asking time.
I wanted to do it April 21st, but y'all convinced me to take an attorney, and I didn't get to do anything I wanted to.
No, you can do anything you want, sir. The fact that Tom Burbank, an experienced attorney, is helping you is to help you, not to dictate anything. It's your life. You get to make the call. If you want to represent yourself, then you're entitled to do that. But in 20 years here, a defendant has never been successful, but that's your choice.
Then why did he tell me that I couldn't have any of my motions that I filed before he was appointed to be ruled on?
Well, if I could read his mind, I guess I would know, but how would I know what's on his mind on those? I don't know why he would say that. That's why you were supposed to work. Why didn't you ask him that?
I did.
But what did he say? I'm not going to answer you?
He said I'm going to get ruled on.
Sir?
At all. Like, I got certain motions that I filed that I wanted ruled on.
Okay, what?
The motion for dismiss, I wanted ruled on.
It's denied. I've read that. It is denied. It doesn't have a legal basis. What's next?
And then I want to ask why I filed a habeas corpus and was never brought to court for it for the bond reduction. My bond was changed from 400,000 to no bond without me being present in the courtroom without my knowledge.
All right, that it won't hold up this trial. A fact of a bond. We're moving forward. You're set for trial today. What's next?
That ruled on my speedy trial.
It's denied. What's next?
My speedy trial motion is.
It's denied. You're getting a speedy trial. Here we are.
I filed it over a year ago.
It's being granted today. We're moving forward.
All right.
We're going to try the case today. This is what you want. This is your time, and make it wisely.
Fair trial in this courtroom, but we need to go forward, and that's fine.
Thank you. Okay. Yeah. Well, anything else?
No, Your Honor, I will stay on if he needs any assistance.
Neil, stand by. You want to represent yourself. All right. You understand and appreciate how these procedures work, the rules of evidence you're going to be held to. And if you don't have adequate legal counsel, like Mr. Burbank is more than adequate, a very competent man, then you understand you're a layman, and you're going to be starting with about a 3-touchdown lead for the prosecution, because you don't know these rules, and it's just like in a ball game. They have to be followed, or else you are going to be are not going to be on the same level. And that's what competent lawyers do, is make sure that your rights and the laws are followed, the rights are given to you and allowed, and that both sides receive a fair trial. When you're not capable of knowing that, I've been doing this for 40 some odd years in prosecuting, in defense work, judge, and defendants never come out ahead in that regard. Do you understand? Knowing all, as long as you know that, you're grown up. You can make your choice, but it's a foolish choice to make if you don't want him to handle the case. What I'm going to do, right? You don't want it.
I just want to make sure my rights are reserved. So.
You've made your decision voluntarily, knowingly, intelligently, and that's what you insist on.
Your Honor, I have all my trial notebooks. I'll bring that so that he may have. I'll have the law books that I use so that he has everything provided to him. And we'll be here if he has any questions.
All right. He'll be standby. He won't be representing you. He'll be standby if you need to get some advice from him. He'll be close by. You ask for that, and I will decide how much time. But we're not going to delay the case. We're not going to delay on you going and talking to him over and over and over again. You want to represent yourself. That's the way to do it, or else it would take months to try cases. If you went and asked him every question on every question asked and every issue, but he'll be standing by. The court will allow you if it's proper, and that is the way it is done.
Can I say something, please?
Yes.
So I think 3 weeks he's been appointed to me. I mean, that's not a lot of time to even really officially get stuff ready at all. Like for over 2 years, I had no representation whatsoever. Nobody helping me, no nothing. So I mean, that's how I'm saying it's just not fair.
Why is that? Do you think?
3 weeks?
No. How long have you been in custody?
I've been in custody for 27 months now.
27 months.
Yeah.
Judge, we had this discussion, to be fair to Mr. Adams, we had this discussion. He claimed that no one had come to contact him. None of his lawyers had gone over any of the discovery with him. And then Mr. Burbank got appointed. And then
Well, John West when was John West appointed? I go back on July 7th. Where's Mr. West?
Right.
John?
Yes.
You were representing him?
Yes, I
Back
was.
2 years ago. Did you just disregard everything?
No, I talked to him several times back then. He didn't want to do anything. Didn't want the offer, and I was like, okay, it was set for trial docket.
Okay, y'all, when you set it for the trial docket, were you prepared to try the case?
I was prepared back then until he wanted a different attorney, and that's when I got off. And actually, I got off because we found out eventually that I represent a co-defendant on this too. That's correct. And so at that point, I had to get off of it. That's why.
When was that?
I don't remember when that was.
Well, help me out.
How long you been off?
I'm back. So it's
Probably before that time
there was somebody else.
Well, Miss McNally was his attorney for a while.
Whenever I got off, whoever took over after me, I'm not sure.
But for 2 years, you were representing.
Was bad. I didn't hear you.
Oh, wait outside. Yeah. No, down to the. Hey, let me go. Wait outside. Let's go. Follow.
What happened? What was that?
I've been waiting. You know, everybody important. And it's that.
Yes, sir.
John West talked to me twice here at the courtroom, only offered me the 15 years. He only came one time in jail. He brought no case file, no that type of nothing. He ain't shown me anything. I don't know. He might be confused with somebody or something, but the only reason why he came and see me was when my dad called him several times. He came to see me for the first time in the jail ever, January 5th, 2024.
How many times would you say you've seen it?
Yeah, I wouldn't even.
Give me come on, you've got, but I represented people, and every time I went to talk to them, I noted it. But how many times did you say you started doing in 2 years?
Several times, because it was here at the courthouse.
10 times?
Less than 10 times. I wouldn't say 10 times. No, I wouldn't say that. I'd say probably 5, 6.
How much time would you say collectively? Is it normal over that period of time that you discuss things?
My clients, yes, sir. That's about normal. I mean, I don't see them all in every week. I don't go to see every single client I have because I have such a, 200, I see 217
I
cases.
understand.
But yeah.
Everybody is important. They
Yes.
has to be prepared.
Yes.
I haven't seen anything against me until Mr. Burbank was appointed to me.
When did that happen?
I still haven't.
And when was he appointed to represent you, sir?
Mr. Burbank,
Yes,
he
sir.
came and see me, April of April, a month ago. I've only seen him 3 times. I haven't even seen Discovery in full yet. Like, I've seen the police reports and heard of bits and pieces.
What discovery is it that you, Mr. West, what have y'all done? Come on, so he knows something about.
I've actually, Your Honor, I've given him police reports, so he knows exactly.
Is that
what
true?
Everybody is saying.
Okay, why are you telling me that nobody's doing anything? They're providing you the discovery.
There
Don't
is.
misinform the court.
I'm not misinforming you. I said he's helped me. He's been a big help compared to what the guy have done and everybody else has done. Like,
Okay, what is it that you need that you don't have
I
already?
see everything. I want to see Discovery in full.
Well, what is it what do you mean everything? What is it
The
that,
only thing that he probably hasn't seen, Judge, is the interrogation of the co-defendants, but we went over it. I've gone over telephone calls that, Mr. Adams has made, that are probably not exculpatory.
Mr. Laird, is that the discovery essentially what Mr. Burbank is talking about?
Yes, sir. Yes, sir. There's some.
He's provided it to y'all and he's provided it to you. There's not tons of stuff here, apparently. So
Last week we provided him with the jail calls that we discovered. We go through his jail calls. So
what else is there that he hasn't received? Anything?
Nothing.
Nothing.
The only thing he hasn't seen, Judge, is,
Why would you say that you don't have anything when the lawyers, this prosecutor and your defense attorney now say they provide you everything they have?
No, that was everything. Nobody-
Okay, that's it.
Everything. No,
Okay,
not lying to nobody. I'm just trying to make sure that I get a fair trial.
okay. So you got the information according to them. I don't know what it is, but they say it is. All right,
we have close coming at 12:30.
all right.
I'll get you closed.
You're up first. Case.
You're with you.
I'll speak to you for a minute. I'm fair.
Okay.
Okay, here. Thank you.